In the pursuit of justice, courts often encounter complex issues that require specialized knowledge. These can range from deciphering intricate financial transactions to understanding the science behind DNA evidence. This is where expert evidence becomes critical. Expert evidence offered by individuals with specialized knowledge and experience helps courts understand complex issues and make informed decisions. The Qanoon-e-Shahadat Order 1984 lays down the framework for admitting and evaluating such evidence in Pakistan's legal system. Expert witnesses play a crucial role in legal proceedings. They provide insights that are beyond the understanding of judges, lawyers, and the general public. Their testimony can significantly influence the outcome of a case. This is why it's essential to have a clear legal framework for expert evidence. The Qanoon-e-Shahadat Order 1984, specifically Articles 59 to 65, addresses this need. These articles provide guidelines on who qualifies as an expert, what kind of evidence they can present, and how courts should assess their testimony. Understanding these provisions is crucial for anyone involved in legal proceedings where expert evidence is presented. The importance of expert evidence cannot be overstated. It bridges the gap between complex technical matters and the law, ensuring that justice is served based on a comprehensive understanding of the facts. The following sections delve deeper into specific articles of the Qanoon-e-Shahadat Order 1984 to shed light on the application and implications of expert evidence in Pakistan's legal system. Article 59 of the Qanoon-e-Shahadat Order 1984 lays the foundation for understanding expert evidence. It states that the opinions of individuals specially skilled in areas like science, art, foreign law, handwriting comparison, or fingerprint identification are considered relevant facts. This means that such opinions can be admitted as evidence in court. This article recognizes that judges and lawyers may not possess expertise in all fields. Therefore, it allows for individuals with specialized knowledge to assist the court in understanding complex issues. For instance, a forensic scientist might be called upon to analyze DNA evidence, or a financial expert might be asked to interpret complex financial transactions. The article emphasizes the requirement for the expert to possess special skills. This implies that the individual should have more than just general knowledge or experience in the relevant field. They should have demonstrable expertise acquired through education, training, or practical experience. This ensures that the opinions presented before the court are based on sound knowledge and are reliable. The article's broad scope, encompassing diverse fields like science, art, and foreign law, highlights the importance of specialized knowledge in various legal matters. The application of Article 59 can be best understood through real-world examples. Pakistani courts have relied on expert evidence in various cases, showcasing the practical implications of this article. In the case of Muhammad Saleem versus State, the court relied on the testimony of a ballistic expert to determine whether the bullets recovered from the crime scene matched the weapon allegedly used by the accused. The expert's analysis and opinion played a crucial role in the court's decision-making process. Another case, Ghulam Shabir versus State, highlights the importance of handwriting analysis. The court in this case relied on the opinion of a handwriting expert to determine the authenticity of a disputed signature on a property document. This case demonstrates how specialized knowledge can be used to resolve disputes related to document verification. These cases illustrate how expert evidence, as defined in Article 59, assists courts in understanding complex issues and reaching informed decisions. The opinions of experts in fields like ballistics, handwriting analysis, and fingerprint identification provide valuable insights that aid in the pursuit of justice. The courts, by relying on such evidence, acknowledge the importance of specialized knowledge in legal proceedings. These examples showcase the practical application of Article 59 and its significance in the Pakistani legal system. While Article 59 defines who can be considered an expert, Article 60 of the Qanoon-e-Shahadat Order, 1984, delves into the qualifications and acceptability of expert opinions. It emphasizes that the court must be convinced of the expert's qualifications and the reliability of their methods before accepting their opinion as evidence. The article highlights that mere possession of knowledge or skill in a particular field is insufficient. The court must be satisfied that the expert's qualifications are relevant to the facts of the case. For instance, a heart surgeon's expertise might not be considered relevant in a case involving software patent infringement. Furthermore, the court must be assured that the expert's opinion is based on reliable methods and principles. This means that the techniques used by the expert should be generally accepted within their field of expertise and should have a sound scientific or technical basis. The court can inquire about the methods used, the data considered, and the reasoning behind the expert's conclusions. This ensures that the opinions presented are not just subjective beliefs but are based on sound principles and methodologies. This scrutiny helps maintain the integrity of expert evidence and prevents unreliable or unsubstantiated opinions from influencing the court's decision. Section 5, Handwriting and Fingerprints, examining Articles 61 and 62. Articles 61 and 62 of the Qanoon-e-Shahadat Order 1984 specifically address two commonly encountered forms of expert evidence, handwriting and fingerprint analyses. These articles provide guidelines on when such evidence can be admitted and how it should be evaluated. Article 61 states that if a document's writing is in question, the court can compare it with handwriting acknowledged or proven to be that of the person in question. This comparison can be done by the court itself or with the assistance of an expert. This provision allows for the authentication of documents and helps determine whether a particular person authored or signed a document. It plays a crucial role in cases involving forgery, disputed wills, or contractual agreements. Article 62 deals with fingerprint evidence. It allows for the use of fingerprint comparisons to establish a person's identity. Fingerprints, being unique to each individual, provide strong evidence in criminal cases, especially in placing an accused person at the crime scene. The article recognizes the scientific basis of fingerprint analysis and its reliability in identifying individuals. These provisions highlight the importance of forensic evidence in legal proceedings. They provide a framework for the admissibility and evaluation of handwriting and fingerprint evidence, crucial in ensuring accurate and just outcomes in legal disputes. Section 6, the weight of evidence, cases haiki, fintes, candidates. Case law examples of Articles 61 and 62. The application of Articles 61 and 62 can be further elucidated through case law examples. In the case of the court relied on handwriting analysis to resolve a property dispute. The disputed document, a sale deed, was compared with the known handwriting samples of the alleged seller. The court, relying on the expert's opinion, concluded that the signatures on the sale deed were forged, highlighting the critical role of handwriting analysis in detecting fraud and ensuring justice. In another case, where fingerprint evidence played a pivotal role in securing a conviction, The accused's fingerprints were found on the murder weapon, directly linking him to the crime scene. The court, relying on this crucial piece of evidence, found the accused guilty of murder. These cases underscore the practical significance of Articles 61 and 62. Handwriting analysis and fingerprint evidence, when presented and evaluated appropriately, can provide compelling evidence in legal proceedings, aiding in the resolution of disputes and the delivery of justice. The courts, by relying on these forms of expert evidence, acknowledge their scientific basis and their value in legal proceedings. These examples demonstrate the real-world application of these articles and their importance in upholding the law. Section 7. Medical opinions in court, delving into Article 64. Article 64 of the Qanoon-e-Shahadat Order 1984 focuses on medical expert evidence, recognizing the importance of medical opinions in legal cases, particularly those involving personal injury, medical negligence, or homicide. The article states that when the court needs to form an opinion on a medical matter, it can rely on the opinion of a person with special knowledge or experience in the field. This provision allows for medical professionals such as doctors, surgeons, or psychiatrists to provide their expert opinions on matters related to injury assessment, cause of death, mental competency, and other medically relevant issues. Their testimony can be crucial in determining liability, assessing damages, or establishing the mental state of an accused person. For example, in a case involving a car accident, a medical expert might be called upon to assess the injuries sustained by the victim, determine the long-term impact of those injuries, and provide an opinion on the cause of the injuries. Similarly, in a criminal case, a psychiatrist might be asked to evaluate the mental state of the accused at the time of the offense, which could be relevant to their criminal responsibility. The court, guided by Article 64, relies on the expertise of these medical professionals to understand complex medical issues and make informed decisions based on reliable medical evidence. Section 8. Evaluating expert testimony, the court's role as per Article 65. While expert evidence can be highly persuasive, it's crucial to remember that it's ultimately up to the court to assess its credibility and determine its weight. Article 65 of the Qanoon-e-Shahadat Order 1984 emphasizes that the court is not bound to accept expert opinions as conclusive proof. The court has the discretion to either accept or reject expert testimony based on its own assessment of the evidence and the circumstances of the case. The court, in evaluating expert testimony, considers several factors, including the expert's qualifications, the reliability of their methods, the consistency of their opinion with other evidence, and the expert's demeanor during testimony. The court might compare the opinions of different experts, examine the expert's potential biases, and scrutinize the reasoning behind their conclusions. This ensures that expert evidence is given appropriate weight and prevents miscarriages of justice due to blind reliance on potentially flawed expert opinions. Case law provides insights into how courts exercise this discretion. In Judicial, the court rejected the opinion of a ballistics expert because it found the expert's analysis to be inconsistent with the other evidence presented in the case. Similarly, in Judicial, the court questioned the credibility of a medical expert after finding inconsistencies in their testimony and a lack of proper documentation to support their conclusions. These cases highlight the active role of the court in evaluating expert evidence. The court acts as a gatekeeper, ensuring that only reliable and credible expert opinions influence its decision-making process. This critical evaluation of expert testimony is crucial to prevent miscarriages of justice and maintain the integrity of the judicial process. Section 9. Conclusion: ensuring justice through reliable expert evidence. Expert evidence plays a vital role in Pakistan's legal system. It bridges the gap between complex technical matters and the law, enabling courts to make informed decisions in cases involving specialized knowledge. The Qanoon-e-Shahadat Order 1984 provides a comprehensive framework for the admissibility and evaluation of such evidence. Articles 59 to 65 of the order outline the qualifications of an expert, the types of expert evidence admissible, and the court's role in assessing its credibility and weight, from defining who qualifies as an expert to outlining the court's duty in scrutinizing expert opinions. These provisions ensure that only reliable and relevant expert evidence contributes to the pursuit of justice. Understanding these provisions is crucial for anyone involved in legal proceedings where expert evidence is presented. By adhering to these guidelines and ensuring that expert testimony is carefully scrutinized, the Pakistani legal system strives to uphold the principles of fairness and justice, ensuring that decisions are based on a thorough understanding of the facts and sound legal principles. The continuous evolution of science and technology necessitates constant vigilance in evaluating expert evidence. As new fields of expertise emerge and existing methodologies advance, the courts must remain adaptable and critical in assessing the reliability and validity of expert opinions. By striking a balance between recognizing the value of expert evidence and scrutinizing its limitations, Pakistan's legal system can ensure that justice is served effectively in an increasingly complex world.